Hello, Mr. Hogen.
Oh, you're right.
All right, why is your daughter not with us? I'm used to seeing her now. Is she back in school or studying?
You need to talk to the She took the LSAT.
Yay.
I've given up to taking a different. I'll tell you something. I think she did great, but she really stars.
No, because do they still do that? I remember they said if you took the LSAT and then you did another one, then they would just average it. You can't just say, they don't do that anymore? Oh, you can take it as many times as you want to.
You can only take it 5 times.
Oh,
I'm not up on the rules, but I know the rules have changed.
I challenge all of us to take the LSAT again. It'll bring back memories. Bad memories, right? All right, so on this case, are we here on a motion to revoke? What are we here for?
We are, Your Honor. We're here on a motion to revoke, and I believe the state filed a motion to amend the motion to revoke, and it was filed on September 29th. Yesterday.
All right, just 1 second. Okay, there's nothing attached to this.
He said that the DA's printer has lost ink and it was emailed to them.
Right away, you can see how messy these probation revocation cases get. The state is amending motions. The defense hasn't had much time to prepare, and even the judge is pointing out inconsistencies, like missing lab results for a drug possession charge. This is a great example of how technicalities matter in court. Without lab results, that allegation essentially collapses, leaving only the original violation on the table, missing a drug test. Imagine being in Hogen's shoes, thinking you're fighting multiple charges, only to find out half of it doesn't even stick.
I'll accept. I'm fine with service by email. That's good.
Okay, all right, thank you.
I wrote it on there too, Judge. Email to the best guys.
All right, thank you.
We're working on getting the ink restored.
All right, thank you.
Part-time for the county judge.
All right, thank you. And then on Hogen, I don't have the motion to revoke file. Hogen.
It should be printed out there.
Right, all right. And so it's set for today. And what is the issue?
Your Honor, the first amendment was filed yesterday. This is the first chance I've had to get to talk to my client. I was wondering if I could have some time to prepare him and talk to him about this case.
All right, do you have the original motion to revoke? Because I only have the First Amendment. Where's the original?
Would a copy suffice?
Rashad is bringing it.
Oh,
Thank you. We made it. So the only thing that I see that's been added is a possession of a controlled substance.
Yes, Your Honor, that's one of the new number 1.
All right, do y'all have labs for that?
We do not. It just occurred.
Then labs, are y'all expecting to have those labs in 2
No,
days?
I told counsel there's no way we'll get those back anytime soon.
So then the First Amendment really has no bearing because they're not going to be prepared to proceed on the violation of condition of number 1, possession of a controlled substance. So I don't know why it was added. They don't have any labs for that. They're not going to have labs for that. And it'll probably be 6 months or whatever before they get labs for that. So really the only thing that's going to be proceeded on is probably the original.
revision.
Yes.
Can we on that right now? Yes.
Stay.
May I see the?
Yes. And just mention the one thing.
Sure, Your Honor. Yeah, we just so the court knows, on the original, the other new number 1, the evading, was dismissed by our office. So literally the only thing left is the number 2.
Okay. Can I have a file stamp, please? Yes. So is this a case that criminal trial division or is family violence going to handle? Because there's nothing that will be left in here that is criminal trial division. The evading has been dismissed.
Your Honor, my understanding before that was the discussion is that we were going to handle it, but I haven't conferred with family violence since.
All right, if you want to confer maybe with family violence, because it appears that the only thing on this motion is going to be failure to submit.
And we're gonna plead truthfully.
Okay. So I don't know if who's going to be making the recommendation on their side.
Your Honor, I'll proceed on.
All right, the court is calling 2024 CR 0077778 State versus Christian Grant Hogen. Can I have parties announce?
Melissa Albin for the state.
And Eric DeWalt, I represent Mr. Hogan.
And are you Mr. Hogen?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, I did.
Are you the same Christian Grant Hogen who was placed on deferred adjudication in 2024 CR 0077778 for the offense of assault family household member impeding breath or circulation on October 31st, 2024 for a period of 6 years? Is that you?
Yes, ma'am.
All right, state.
You can proceed on number 2, Your Honor. On or about the 15th day of August 2025 in Bear County, Texas, the defendant Christian Grant Hogen did then and there fail to submit to drug testing as directed by the supervision officer in violation of condition number 2.
How do you plead to that, true or not true?
And there it is, the turning point. By pleading true, Hogan is admitting to the violation. That might seem minor, but legally it's huge. He's now exposed to the full range of punishment, up to 10 years in prison and a $10,000 fine. This is where strategy comes in. Sometimes defendants plead true hoping for leniency, but it also ties the judge's hands. What do you think? Was this a smart move by his defense attorney or a risky gamble that could backfire?
True, Your Honor.
State.
We'll waive the rest, Your Honor.
Any objections to the waivers?
Mhm.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine?
May I speak on that?
Now, my question is, do you understand
Yeah,
that?
ma'am, I do.
Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
My understanding is there is not, Your Honor. The state is recommending that we follow the probation department's recommendation, which is to have the defendant submit to SATIF, withdraw the MTR and alter and amend his conditions for SATIF.
All right, so the MTR can no longer be withdrawn because he's
Oh,
already played.
That's right, Your
Stop.
Honor. I apologize.
No
But,
problem.
That's what we would recommend, is that he go to SATIF.
All right, so defense, what are you requesting?
Your Honor, exactly that. I just spoke to my client. He was under the understanding that he had a possession of drug paraphernalia when he did complete SATIF and does have a full-time job and understands he's going open to the court. He missed this one drug test because he couldn't get there on time. He has drug tested before and they've all come out negative. This is his first MTR. He seems to be doing very well on the deferred adjudication. He understands he's up in front of you with the full range of punishment and kind of going open to the court, but wanted to address the court and ask that if he could have a less structured modality that he could continue to work.
All right. Before you address me, any objection? I haven't opened it yet, but any objection to the court reviewing the court summary? All right.
Next. Or do you?
Oh, yes, they emailed me.
Okay.
I receive it by email, but I don't open it until parties have no objection. All right, probation, what are you recommending?
The recommendation is for residential treatment at SATIF followed by the aftercare and continued on the ISD case.
Is it possible to do, just do the aftercare portion, or has the time frame between being in SATA?
Well, he didn't do SATF the first time, Judge. He did local ISF.
Ah, okay.
So as you know, local ISF is more geared to cognitive, and then the SATA has that substance abuse. I was in the midst of looking up why he did not qualify for a drug court. If you would
Yes,
like to know that.
yes. And then you want to raise your right hand for me?
Yeah.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
My name is Christian Grant Hogen.
All right, so it appears there's something you wanted me to
Yes.
hear. Did you want him to speak to me, counsel?
This moment right here shows why Judge Boyd has a reputation for being tough but fair. Hogan tries to downplay his missed test as just one time, but the judge shuts it down immediately. In probation, there's no such thing as just once. Missing one condition, even once, can get your probation revoked and land you in prison. It's a sobering reminder that probation isn't freedom. It's a second chance with very strict strings attached.
That's his intention. It's your intention to address the court.
Yeah,
Correct?
ma'am.
Yes.
I just want to let you know, ma'am, I understand this, what they're recommending. I just feel like, and you've been fair since I've been in your courtroom, ma'am. I already completed ISF, which, is.
So here's the thing. Let's get to the crux of the problem.
Yes,
The
ma'am.
problem is you didn't report for your UA. Why?
One time, ma'am, I was
No,
there.
no, no. Let's not do the one time.
Well,
Because one time is enough.
ma'am.
Wait. We have to speak one at a time. And so let me explain something to you. So don't tell me it was only one time. And the reason why I tell you not to tell me that is because those are conditions of your probation. One time for anything is enough for you to be revoked and sent to prison. So don't say it was just one time, because that's making excuses, right? Just tell me, why didn't you report?
Well, when I first got out, ma'am, I'm gonna get to that. I was doing well. I was remodeling homes with my brother, and I was always in contact with my probation officer, and I had just lost my efficiency, ma'am, and so being in the streets, having my things stolen, lost the storage, and so and these are not excuses, ma'am, these are the truth. I had trouble with cell phone, and I always made sure I emailed when I didn't call her, and so fast forward to the motion to revoke. I had just over there, I want to say 7 days prior to the motion to revoke, because I hadn't been able to speak to her, and that's the reason why I missed it, because I'm having to deal with wanting to get shelter, and I was living in Fishing, and I went to the hotel, and it was just hard, ma'am, and that's just all I can tell you.
Here's the thing. I'm going to give you a choice. These are your choices. There's no other choice, right? Here's your choice. I can revoke you and I will sentence you to 2 years in the prison. That's one choice. Or either your second choice, I will continue you on probation. And what I'm going to do is it's going to be an intensive supervision. And I'm going to start you off.
And here comes the twist. Instead of revoking probation and sending Hogan to prison, Judge Boyd gives him a choice: prison time or continued probation under strict GPS monitoring. This is a huge lifeline. Think about it. One missed drug test could have destroyed his future. But now he gets another chance, though under intense supervision. Was this the right call? Some would say the judge showed compassion. Others might argue he was too lenient given the original assault charge. What's your take? Would you have given him another chance or locked him up?
With GPS, and that will be partial GPS for employment only. Those are your two choices. There are no other choices. Do you need to discuss that with your attorney?
No, ma'am, could you please waive the fees on the GPS?
Yes.
Yes, ma'am, I can do it. I can do it, ma'am.
All right, Ms. Abrams,
Thanks.
I'm going to deny the motion, alter and amend conditions to include partial GPS for employment only, waive fees, and intensive supervision with probation and intensive outpatient treatment with probation. Is there anything else?
Nothing on the speaker.
Ms. Abrams, is there anything else?
No, sir.
Anything else you need from the court to be successful?
You helped me out with everything as well.
You're welcome. Anything else?
Can I just clarify, he's on deferred adjudication, correct?
Yes. All right, thank you.
Judge, thank you for all your consideration as
You're
well.
welcome.
Appreciate
You're
it.
welcome.
So, to wrap this case up, Christian Grant Hogen admitted to violating probation by missing a drug test. The state wanted revocation, but Judge Boyd denied it, instead imposing strict GPS monitoring and intensive supervision. This case perfectly highlights the balancing act judges face, punishing violations while still leaving room for rehabilitation. It also shows how one small mistake on probation can nearly cost someone their freedom. If you found this case as fascinating as we did, make sure to hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. You won't want to miss what comes next inside Judge Boyd's courtroom.